not my language. Neighborhood Building Owners Alliance, we consist of 9 neighborhood building owner organizations throughout the city. 8 are geographically based everywhere from Rogers Park down to the south side to the greater Austin area. And we have a brand new group called the Latino Real Estate Investors, Sonia, what is it, Coalition? Council, I forget. But we are proud to have these 9 groups, and we're there to promote the interests of neighborhood building owners. And an issue like the one we're covering today has been a big focus of ours this year. I'm joined in this call with a colleague, a fellow board member, Michael Zink. Michael does real estate law, focusing on landlord-tenant rights, representing mostly those of us on the industry side. His law firm is Star, I'm going to butcher it, Bezert, Zink, and...
Bezert, but you're close.
Bezert, okay. And you too are wearing a tie. What, do you work for the city too, or what?
I had court calls all morning.
Okay, there you go. So we're going to hear from Michael in a couple minutes. But I'm going to start the topic. You know, ever since the NBOA formed 17 or 18 years ago, we've always kept an eye on the eviction process. Let it be said that none of us like evictions. None of us want to evict folks. This is not the preferred outcome. We're in the business of putting people in apartments and running good buildings. The thought of having to kick somebody out is just a dreadful idea. Unfortunately, it's oftentimes the lone remedy that we have, and it's a remedy that is universal and nothing anybody enjoys doing. So we've always had concerns about the slow pace of evictions, you know, and it's not just the property owner that's impacted by a slow process. You know, it's our willingness to take chances on people who might not fully qualify, that perhaps has a mark or 2 or 3 on their record, to take a chance on a prospective new tenant. It's a little more challenging to take chances if it takes 8 to 10 months to follow this process through to the end. COVID changed this whole dynamic. We all know this. We suddenly were hit with an eviction moratorium, which is unparalleled, I believe. And we struggled through that. We then heard after a while that, don't worry, the federal government's going to step forward and provide money to reimburse us for the pain of holding back, for us using grace and patience and understanding that people needed a place to live during COVID. Most of us were quite magnanimous and worked with tenants. The fact that the government was coming through with rental assistance, again, a tremendously unusual concept. And in many ways, this notion of emergency rental assistance helped. At the end of the day, we'll learn how expensive it was, if it was worth it. But I don't know the exact dollar amount, but I know that over $1 billion was brought into the state of Illinois. IDA did a tremendous job and received adulation and recognition. And I believe the city of Chicago and the county, Cook County, all received great marks compared to other jurisdictions for how they dished out the emergency rental assistance. I don't have to get too far into the rental assistance for this conversation, except to say that the last time that the bulk of the money was available was December of last year. There was new money available, a big demand on that money, and then the program's cut. So the money would flow from the state to the city, from the state to the county. There were 3 pools of money we could choose from. I think many of you are on this call today because you want to know if you have a tenant who's still struggling, who might have a COVID-related hardship, that there is still money available. And we're going to learn about that from Dan Cassell with the city, and we'll get to that a little bit later in this call. The other main change in the eviction process that happened during COVID was the introduction of a new program. And, you know, for those of you who like acronyms, we could go to town on this, because emergency rental assistance is called ERA or ERAP, Emergency Rental Assistance Program. And then a new program that was introduced during COVID, which is seemingly here to stay, goes by another acronym, and that's ERP, Early Resolution Program. And we're thrilled to have the architect of this program, Bob Glaves, the executive director of the Chicago Bar Foundation, on this call. We'll learn a little bit more about what the Chicago Bar Foundation is, and more importantly, we'll learn about the outcome of a number of discussions that we at the NBOA, Mick Snyder with Spear Communications, took lead on this issue, worked with Michael Zink, and we engaged in a number of conversations with Bob Glaves, who showed great concern over some of the problems that we've been having this year. And we are also have on this phone call, besides Bob Glaves with the Chicago Bar Foundation and Dan Cassell with the city, we have two additional folks aboard. We have Carmen Navarro Jercone, and pardon me for butchering your name if I butchered it. She's with the clerk of the circuit court's office, a vital component in the whole eviction process. We'll learn about some of the challenges that the clerk's office has been dealing with, and because that's been one of the issues that's been an obstacle and a challenge. But and we'll learn why and what the clerk's office is doing. We're also going to hear from another name I'm going to butcher, George Vernazos with the sheriff's office, and George is the special, I butchered it. You're the special counsel, or George, you'll tell us what you are. But you can update us on any relevancy that in the actions of where the sheriff's office is in this eviction process. With that being said, I want to say that these calls are open to everybody. We have local housing providers, we've got attorneys, and we also have tenant advocates, I'm sure, on this call. Everybody's welcome. It's a conversation meant to educate and find out what the most just and prudent solutions are, so we can get back on track and have a thriving, successful, stable neighborhood housing in the city and in the county. With that being said, I'm going to turn it over to Michael Zink, who's going to take us through the eviction process, realizing that some of us might need a little eviction process 101 reminder of where things were and where things presently are. So Michael, take it away.
Thanks, Mike. Thanks so much for having me. And I see a lot of familiar faces on here. So, echo me if I leave something out, or if you think that there's something else missing. But yeah, as Mike said, the eviction process has changed dramatically in just the last little over 2 years, as with the rest of the world. So I figured it would make sense to kind of go through pre-COVID numbers in terms of how long things took, as well as the processes that were involved, and how it's evolved over the last 2 years. Because in 2021, it was slightly different with some additional steps involved, and now it's even further different with some additional steps involved. So I don't know, Mike, do you have that graphic that you wanted to show, or Maggie, and I can follow along? Otherwise, I could just kind of start the explanation verbally. There we go. So the graphic on your screen is kind of a very general overview of the process for evictions. This one is for pre-COVID. So basically before March of 2020. You would file your eviction lawsuit like any other lawsuit. Typically your first return date potentially was about 15 to 17 days out. If the sheriff was able to serve the tenants, then the first court date would be that 15th or 17th day. But even if the sheriff was not able to catch the tenants with the summons, typically then you would appoint a private server. And even if that private server was not able to catch these tenants, you would proceed to a posting notice. Even if you were required to go through that whole process of going through the sheriff, private server, and the posting notice, it wouldn't take more than approximately 4 weeks, perhaps 6, to get through the whole thing. And that would be your first court date. If the tenant showed up, then they might get a continuance to retain an attorney, or if they filed a jury demand or filed other pleadings, all that would be dealt with. If the tenant didn't show up, then the judge would enter an ex parte eviction order, meaning an eviction order with a judgment against that tenant in most cases, other than a posting. That eviction order, if the tenant made no efforts to vacate it or get it back into court, that order would be taken to the sheriff, who is taking approximately 5 to 7 weeks at that point. So back pre-COVID, most cases would be done, as the graphic says, give or take 24 weeks. It's not an exact science in terms of the number. It's sometimes was less, sometimes was more, but more or less it was about a 3-month, 4-month process, even if a tenant got involved and started putting up fights or delays or defenses that they were filing. Then in 2021 was the beginning of our ERP process that Mike had mentioned, and that'll come up on the screen in a moment, I believe. So in 2021, with the commencement of the ERP process, there we go. The first day of the court date, again, before the ERP rules really were fully implemented, we're about 3 weeks, 4 weeks out. And again, there were additional delays involved with it. Now, the ERP process, for those who aren't familiar with it, is not a mediation. A lot of people think it's a mediation where you're forced to talk to a mediator and go through, try to get a resolution. That's not what it is. The ERP is essentially an opportunity for tenants to get help. Sometimes it's through a legal aid attorney. Sometimes it's through some of the administrators at the courthouse, and there are ERP administrators who guide them along. Essentially, these people just tell the tenants their options. These were not things the tenants were ever given before, and so these are the new program that tenants are given to understand what they can do, what their options are. Sometimes they result in settlement agreements, even to this day. It varies widely in terms of the success of the program. In some cases, we've had some significant success. With some of the small and mid-sized housing providers, it's been a lot harder to get that success for a variety of reasons. Sometimes the tenant doesn't communicate with the ERP folks. Sometimes the tenant doesn't have any kind of a resolution in mind. And so back in 2021, at least, when the ERP was introduced, it introduced some additional delays to the system. And without going through each of these individual steps, and these are all contingent steps as well that don't happen in every case, but do happen in some, in a worst case scenario during 2021, more or less you'd be looking at 27 weeks. It sometimes was a little more, occasionally was a little less, but more or less you were still looking at about 4 or 5 months to get the process completed from the time that you filed the case to the time that a sheriff actually enforced the eviction order through execution, in other words, performing the physical eviction. 2022 now, and I think that'll come on your screen in just a moment, the ERP process has been honed largely through the efforts of the courthouse and Bob Glaves, who's with us, and Bob's been working with the NBOA with suggestions as well. And I know the NBOA is very appreciative of his efforts in hearing everybody out. And the same can be said for the judges as well, for hearing all the concerns that were being that everybody was experiencing during the last year of the implementation of ERP. The new timeline that's on your screen now is pretty accurate in terms of what we see up to this day. So the first court date now under the new ERP system is at least 30 days out from the day of filing. So you remember before COVID, I had mentioned you would get a 15-day, maybe 17-day date. Well, now when you file your case, automatically in the computer system, you are given a date of no less than 30 days. Typically, right now it's about 40 to 45. Some of the lawyers on here know that really has yo-yoed a lot in the last 3-4 months, especially. Sometimes we would file cases and our first potential return date wasn't until 100 days out. So in other words, we would file a case in January and our first potential return date for court wouldn't be until mid-April. And of course, if the sheriff was not able to catch the tenants with a summons, then that mid-April date would eventually become a mid-May date, et cetera. And it really added on 2 to 3 extra months to the process. That was not intentional from by all parties' statements. What happened was there was essentially some kind of a computer glitch where caps had to be implemented in there. And so it's been an ongoing process. And again, I know the housing providers as well as the attorneys are grateful to Bob and everybody else who was assisting with that process, because it was a very frustrating time to explain to clients, yes, we filed your case yesterday, but our first possible court date isn't until the next season, you know, three months from now. So now currently it's at least in the last few days, the dates we've been getting have been about 40 to 45 days out. Still not 30 days, but at least closer to 30 than 90. With respect to the ERP process now, just so you're aware, even in a fastest eviction where a tenant doesn't bother participating, doesn't bother appearing in court after they've been served. So let's take that scenario. If we file the case, we get our first return date, say it's 40 days out. The Cook County Sheriff goes out and they succeed in serving the tenant with the summons. And the tenant just decides one reason or another, they just don't participate. They don't come to court at all. Court, of course, is currently on Zoom, so there's still no in-person court required. What happens then is on that first court date, on that, say in that example, 40th day, we will then get continued over for 14 days. Even if the tenant doesn't show up, the case will still be continued 14 days to give the tenant one more chance to show. Then the lawyer sends out a notice to the tenant again by mail, explaining to them your new court date is 14 more days from now. And if the tenant does not show up on that next date, then the judges generally will allow an eviction order to be entered ex parte, because the tenant has now failed to show for 2 required court hearings after they were served. So, but even if that happens, just using the timeframes I'm giving you, you're still talking about that initial court date of 40 days or so, plus another 14 days. And then even then, the judge is going to give them another week or 2 in terms of a stay on the order. So then you're still looking at another 14 days or so, let's say, after that. So even before you take that order in a situation where the tenant does not even bother appearing, the earliest date you're probably going to get that eviction order to the sheriff to begin the enforcement process is not going to be until some 70 days since you filed, which is of course about 2.5 months. And the sheriff right now is taking approximately 3 weeks or so to perform the eviction. And so again, even in a situation, like I said, where the tenant does not get involved, adding 3 more weeks onto that time frame I mentioned, you're looking at about 90 to 100 days minimum. And that's if a tenant does not get involved, does not participate in court at all. You're still looking at least 3 months from the date you filed to the date that the sheriff performs and executes on the eviction order. Of course, if the tenant does appear, whether through an attorney or on their own, there are additional executed continuances. So if we have that first court date 40 days out and the tenant shows up, the judge will automatically continue the case 28 days, sometimes a few days extra, depending on judicial conferences and the like. But the bottom line is if the tenant shows up, your first court date after the initial 40th day will not be until another 28 days or so. Again, so now you're about 70 days out from the day you filed. The tenant during that 28-day period is supposed to, and often do, communicate with the ERP administrators as well as the legal aid attorneys that are involved with their organization. Sometimes things work out, as I said earlier, and sometimes they don't. In my office, we represent mostly small and mid-sized housing providers. It is increasingly rare that we are hearing from anybody at ERP about proposals. And I don't know if that's just an aberration or if that's a symptom of the workers and the attorneys on at the tenant's side just having too many cases to handle. I don't know. But in many cases, especially in recent months, they have not really led to too many resolutions. And so what happens is if we come back on that 40 plus 28, so now 68th day or so since you filed it, if there's no resolution, and often there is not now, then the case will then get transferred to a trial judge. So that first room that you're in on the Zoom, the first courtroom, that's generally called the triage room. Those judges are not going to be entering orders. They're not going to be holding hearings. They will then transfer it to a new judge if there's no resolution. That new judge will give us we will get a date in that new judge's room probably about 2 to 3 weeks later. So that's on top of the 70 days or so. So now we're talking 90 to 100 days before we're in front of a trial judge. And again, this is all assuming that the sheriff is able to catch the tenants right off the bat after the case is filed. So even at that time, when you get in front of a trial judge, you will now get approximately 14 to 28 days for a trial date in that new courtroom. And again, that's all based on the judge's schedule in that trial room, because they can only have so many trials on each particular day. So even if that trial happens, again, assuming that this tenant does not vacate voluntarily, you're still looking at another 14 to 21 days, even if the judge finds in the housing provider's favor and enters an eviction order. So more or less, it's a safe, almost conservative estimate to tell housing providers that from the day you file your case until the day a tenant is actually evicted through the enforcement of an order, it's going to be a minimum of 4 to 5 months, and sometimes it's longer, depending on what happens. If the tenant decides to file a jury demand, that will add time. If the tenant or their attorney files some kind of dispositive motions or other motion practice or other pleadings such as affirmative defenses or counterclaims, that's all going to add on time as well. So it's a safe bet to tell housing providers that if somebody is behind, it's going to be a 4 to 5 month process in court. And mind you, during that time, it's going to be very unusual for a tenant to be paying any of the rent during that period of time. In many cases, they cannot pay the rent, but in many cases, they simply won't want to do it anyway, and it just won't happen. And so it's important that housing providers know that this process has always been somewhat deliberate, but now it is significantly more so, about, like I said, 4 to 5 months. So what does this all mean for housing providers before an eviction? Well, pre-COVID times, the reality was, try to work it out with the tenant, try to stay out of eviction court. Like Mike was saying, it's the last place any provider wants to be, because one way or the other, everybody's losing. It's not pleasant emotionally, it's not pleasant financially. It's simply unpleasant. With this 4 to 5 month delay, what I've been seeing a lot of the housing providers say is, look, if we're going to work something out, let's just at least do it in court. Because if we don't have anything worked out outside of court, there's no way to enforce anything. So in other words, if a tenant says, I promise I'll move in 30 days, the housing provider doesn't know, even if they take them at their word, what happens if something comes up unexpectedly. There's no way to enforce it. And so a lot of housing providers have now taken the position, you get it into court, we can work it out there in terms of a move date, and payment plans. So many of these still can be resolved through payment plans, but again, there's no way to enforce it except when you're in court. And as you'll hear about momentarily, the other reason that a lot of housing providers are taking cases to court now is because of the emergency rental assistance, the ERA program. As Mike alluded, and we'll hear more from our other speakers, currently rental assistance is almost exclusively available through the court-based system, meaning that you aren't going to have access to those quick, full amounts of funds unless and until you're in eviction court. And so this is coming from the federal government too, incidentally. It's not a local rule. The federal government is setting the rules on that in terms of the money being available in eviction court. So in an odd way, it's almost encouraging evictions to be filed so that the provider and the tenant can be made whole with the funds and allow the tenant to stay. So in a nutshell, that's generally the eviction process right now. And I'm happy to answer questions, or I can take them at the end as well.
Let's put them in the chat box. It's almost 12:30, and we're going to be hearing next from Bob Glaves with the Chicago Bar Foundation, and then we'll hear from the city and with Dan Cassell, and we'll also have a chance to get a little further context from Carmen with the clerk's office and George from the sheriff's office, and then we hopefully have a little bit more time. Bob, it's been a pleasure to be getting to know you the past few months. You and your cohort, I think it's Elise, I believe. And
yeah, Elise is here too. Yep.
Yeah, and so tell us about the Chicago Bar Foundation, and then take it away.
Sure. Mike gave a good description of the process. When you don't work out the case, it can take a long time, no question. And it's taking longer right now than it's intended to. So that is something we're working on. So I'll come back to that in a second, but I want to say that at the outset. But we are one of the architects of the program. The clerk's office, the sheriff's office were involved as well, who are here today and have been important partners, along with a lot of other community and other folks. But really it started with the county and the circuit court when the pandemic was starting, trying to figure out how are we going to handle evictions in a fair and efficient way, knowing that we're in a completely foreign and virtual world at this point. Before the moratoriums, or when the first moratoriums were entered, it was thought those were going to be a few months. Obviously, they ended up taking much, much longer. But there was this fear that there was going to be a flood of cases. coming into the courts in a virtual environment where they weren't able to do any jury trials at that point. And so the idea around this program was, what can we do to try to set up a program that can work in the virtual world countywide, so in the city, but also in the suburban districts, that gives everybody access to some assistance up front, where both landlords and tenants, and including mediation, but also just legal assistance, case management, as Michael Zink talked about, and then rental assistance when it's available, to try to maximize, first of all, getting rental assistance into your hands as the small landlords especially, but all landlords, as fast as possible, and resolve cases hopefully without you ever having to file them. But if you do have to file them, early in the process, for the reasons that Michael Zink said, because even before the pandemic, these could take 4 to 5 months. And the fear was this was going to get much worse if we just kept the same process as we had before, because again, they're just starting to do jury trials in the courts again right now. So if there was a whole bunch of jury trials happening, you would just get stacked on top of each other and have even worse potential outcomes than what we're looking at now. So the idea was, let's try to figure out a way we might be able to try to resolve these early with rental assistance when we can. So getting money into your hands whenever possible. But if that's not going to be an option, what's the next best alternative to get a tenant out in a reasonable amount of time from your perspective, but keep them stably housed in their next stop, in a negotiated resolution? Because, I think, Mike, you said it right at the outset. Evictions are tough on everybody, the landlords, the tenants. I've been through the one on the landlord side myself. We've got 2 small landlords on our staff here, so we're very aware of this perspective of what it's like for all of you who are in this boat right now. Most of the conversation around these issues happens around the tenants and the fate of the tenants, and that's important. But we are very concerned, just as concerned, about the landlord side of this and trying to make sure it's a fair and efficient process for everybody. So the process is intended to get help everybody, rental assistance when it's available, and then see if we can work it out early. Michael Zink said, and Michael, we should talk about this more offline, why you're having less success lately, but there have been more than a quarter of the cases have been settling at that early phase since the beginning of the program, and even more a few weeks later. So there's been some success in resolving cases, and the actual evictions enforced by the sheriff are down quite a bit, which is a good sign that some of these negotiated resolutions are making a difference. But what I think,
all right, good to see you, Mr. All right.
Oh, sorry about that. What I think, I know everybody's interested in the 30-day turnaround on the cases. We are trying very hard to get back to that. As Michael said, it's been a little bit long because as case filings have grown, it's trying to match up all the resources with the court process has gotten us a little off track on when the first hearings are happening. So we are making adjustments constantly by the day, literally, to try to get our case filings back to this 30-day date. So you're getting your initial cases in there in 30 days. I'm glad to hear we're back in the 40s, Michael. It's going to take a little bit, but we're hopeful over the next couple months we're on that 30-day turnaround consistently again. We've also had a lot of, particularly in the daily center call, just by the volume of cases, these cases taking a long time when you're in court. If any of you have been involved in that, you know what I'm talking about. To try to work on that process to make that more smooth. That is making some progress, and that's good. And then the last thing that Elise has been working on the last few weeks with some others is when you do file your case and you're a landlord and you want to get access to the rental assistance process started early, you can now do that. So on the cookcountylegalaid.org website, which is the program website, there's a chat bot. I'm not a big chatbot user myself generally, but there's a bot. You go on there, you click the thing, and as a landlord, once you've filed your cases, Elise can put that in the chat. Answer a few questions, and you can actually get an appointment to start the rental assistance process right when you file your case, so that you can get moving early. And again, this is if you're trying to resolve it with the tenant, and rental assistance could be an answer, that you don't get bogged down in the full process that Michael Zink was talking about earlier, where it could take months. You could get that going early and hopefully reach a resolution early in the case.
Deb Zamiak, can you put yourself on mute? Deb Zamiak? I'm sorry to interrupt you.
Oh, no, I see what you're talking about.
Yeah. Maggie, if you can mute her, that'd be great. Okay, go ahead.
So right now that program's only available for cases that are filed in court. We're working on trying to figure out an option where if you file a notice of intent to file, that you might be able to get access to that. The logistics of that are a little complicated, but we're trying to figure out a way so that it doesn't force you to file a case to be able to get rental assistance. And Dan Cassell, we just talked about this yesterday. I mean, the last thing we want to do is set up a process that encourages more people to file evictions, right? From any perspective. So we're trying to figure out a way that we can handle that, and hopefully have an update for you over the next couple of weeks. But I'll be quiet because I know we have a lot of people who are going to talk and be able to answer some questions here. But I do want to thank Mike and Mick and Michael Zink and everybody at NBOA who've been really great partners in helping us work through some of these issues that are, some of them are just unavoidable in a new program like this and a new process like this when it's new, until you start seeing how things play out in real life, how you're going to fix them. But some of them, our goal here is to try to, again, resolve these cases early as much as possible so that they don't result in an eviction. They either result in an agreement where you get your rent paid and the tenant stays, or maybe you get your rent paid and the tenant moves, or worst case scenario, the tenant moves voluntarily, leaves the unit in good shape where you can rent it quickly back on the market. They can make a stable transition and we don't have to go through the whole process with the sheriff. That's what we're trying to do. We want to really move these cases through, though, if they're not going to resolve that way, as fast as possible. So that is what we are trying to do all the time here. And we will keep trying to do it. And we really appreciate all of your feedback, and know it's a tough time. Again, I think we mostly hear about the tenants in the media. We're quite aware of how tough it is to be particularly a small landlord right now. And we really appreciate what you all are doing. And it's important to us to make this program work for you just as much as everybody else. So thank you very much.
Can you just quickly, I think some folks are wondering what the Chicago Bar Foundation, what makes you a vital person in this process?
Yeah, we're the charitable arm of the Bar Association. So for starting point, but we've worked closely with the courts for a long time around setting up court programs to try to help people make the system more efficient, more accessible for everybody, and worked very closely with them during the foreclosure crisis around a mortgage foreclosure program. At the height of, if any of you were involved in foreclosures at that time, when there was 50,000 plus cases being filed a year in the midst of the Great Recession, really difficult program to put together. And that was sort of the starting point for trying to think about this, was the lessons we learned over the years of that program. What can we incorporate here to try to do this? But we've got a long history of working closely with the court and the legal aid community and a lot of community partners on a variety of projects. And this is just the latest iteration and one of the biggest ones.
So among your duties or responsibilities has been this conceiving and implementing this the early resolution program, and has been largely your baby. And because of your position, you have really direct access to some of the major players in the clerk of the circuit court office and the judges themselves. You're kind of a vital cog as these processes are evolving.
Yeah, we are kind of in the middle of it. There's a lot of people on this Zoom I could see right now, from the clerk and the sheriff and the city, who we meet with quite regularly right now to talk about these things. And everybody's working real hard to try to do this. I will let them speak for themselves, but it's been a challenging time for the court, in this time overall, adjusting to the new realities of the new world here, and everybody's fighting through that at the same time as we're trying to put together this program. But we're making progress steadily. And
well, we're pleased to have you here today to explain this and all the work we've been doing the last couple months. And thanks for being so open and accessible to us. I think a lot of folks here really are looking for an update on emergency rental assistance. And the county is directing some of that money to the courts. But since we're a citywide group, we're really pleased to have Dan Cassell, who's the Emergency Rental Assistance Program Director for the Department of Housing. And he can update us and give us a general idea of what's this court-based emergency rental assistance all about, how long will it be around, and what are the processes. So Dan, the ball's in your court.
Sure, thanks, Mike. Well, my name is Dan Cassell. I'm the program director for ERAP for the Department of Housing. Just to give you a background in regards to the ERAP program, we were funded through the Department of Treasury due to the response to COVID. We received 2 rounds of funding totaling up to about $180 million. But for the rental assistance rounds that we had, we've issued out over $162 million for about 24,000 households. But in regards to ERAP, which we've been running since last year, we are at about 170 approved households for funding, which is roughly about $7 million. So I think we've been doing a good job. We still have about 240 applications pending currently. But in regards to the funding, we are committed to fund court-based ERAP through December. We're also, applying for additional funding as well through reallocation, and also we're applying with the state as well to try to get more funding. We'd like to push the program through 2023. That's our goal. But in regards to the funding, we'll definitely be we'll be supporting court-based ERAP in Chicago through December of this year.
So how tell us about the program, and how does it work? How is it different than the previous rounds that didn't require us to bring somebody into court?
Right. So the previous rounds were for tenants to apply online. We processed applications based off AMI, which meaning from lowest to highest. But for court-based ERAP, it's a little different because you're able to access it through court. You refer it through the early resolution program. And we work through the Resurrection Project, which is the delegate agency that process and approve all of our applications for emergency rental assistance. So the way the process works, once you're referred through the breakout rooms, caseworkers will reach out to the tenant as well as the landlord in order to complete the application. Once their application is completed, and we try to encourage those applications. So just to give you a sidebar, we do 2 different types of payment. We do a tenant-only payment, and we do a landlord payment. So if we're unable to get in contact with the landlord, or if the landlord does not agree to the program, we're able to cut the check directly to the tenant. But for court-based ERAP, we're really trying to encourage those landlords to participate, because we've had instances where we've did tenant-only payments, and something could happen and the landlord does not receive their funding. And they would like to hold us accountable for that, which to me, if you just completed the portion of the application, the check would have been issued directly to the landlord. But that's another story. So once like I said, DOH, we do not approve applications. The Resurrection Project approves applications. So once we received approval, we issue payment directly to who is identified as the payee. Right now, and we've had some payment issues in regards to turnaround time. Originally, we wanted to turn those around in 2 weeks. That time has kind of, because we're issuing manual checks and things of that nature. And this is also DOH's first rodeo really at doing a rental assistance type program. So we have had some delays in payment. Payments now have been roughly pushed back to about, instead of 2 weeks, they're maybe about 4 weeks behind. So just want to give you guys a heads up in regards to that. We have supplied like an approval letter on DOH letterhead that the Resurrection Project gives out once the case is approved. So we're hoping that would be, something that can buy them a little more time until we're actually able to get checks out. But so that's pretty much what's going on in regards to court-based ERAP.
Okay, so if I understand, we have a tenant who perhaps didn't pay rent last year, and received assistance. Maybe it was 10,000, maybe it was 20,000. They continually have had whatever reasons for not paying, and they owe a few months' rent. Then we say, hey, there's more rental assistance out there, but we're gonna have to file an eviction to get it.
So Mike, if they have received rental assistance from us and have not paid their rent, they're most likely gonna get flagged for not paying what we originally gave them to pay their rent. So those cases are getting flagged.
So if they didn't pay last year, but they continue to not be able to afford their apartment, are they flagged, or are they still eligible for the funding?
Did they pay their rent to their landlord? See, that's the whole thing. If we approved them and it was a tenant only case and they did not pay their rent.
I'm not saying tenant only case. The landlord and the tenant, or the housing provider and tenant, got payment last year. Say we got money in November, and then December, January, February, no new rent. They say we need more assistance. Then we say, okay, we agree to work with you, but we're gonna have to file an eviction to access court-based rental assistance.
Unfortunately, that is correct.
Okay, so Maggie, can you put that third slide in? I just wanna see how that works. So we file the eviction, and then that little slide that says early resolution mediation, 4 weeks down, that's when we can have the discussion about accessing court-based rental. Is the upper right-hand corner? Is that when we, that's when it's through the ERP that we can access ERA, right?
Yeah, although I
That's
wanted,
correct.
sorry, I'm jumping in here. It's
Go ahead, Bob.
You, once the case is filed, you can try to get that process started by setting up an appointment to work with Dan's folks in the court on the rental assistance, so that you can get out in front of that well before that 9 to 12 week time, by starting earlier using that chatbot there.
Is that
Sorry,
something
Dan, I didn't mean to.
No, this is a discussion. Is that something new, Bob? That ability to
Yeah, that's the, yeah, Elise put the link in the chat. It's on, the chatbot is on the cookcountylegalaid.org website. And then when you click on it, you have to answer a couple questions. It'll ask, is this COVID related? Just say yes. I mean, everything's COVID related right now still. That's a requirement for the rental assistance, but directly or indirectly, you can link everything to that right now. And then it'll, you know, a couple of questions, and then it'll get you an appointment, which can take a week or two, but to get set up, but it'll get you an appointment to start the rental assistance process with. Dan's got a team of folks who are working in the court program who can start that process with them, and the landlord could start that on their own if they need to.
So May 20th, May 18th, tomorrow I file an eviction. We might have a 40-day return. We're waiting for the sheriff to serve the defendant. Can we apply for the rental assistance the next day, or do we have to wait till service of process? Or when can we first tap into that emergency rental assistance?
You could first try to set up the appointment then to get the process started. That's not really dependent on service as much, so that's more to get the rental assistance process going.
Okay, so I want to clarify for everybody, and Dan, you or Bob, it's just a fundamental question asked by Morgan. He said, ERAP, is it closed? What's the technical answer to that? Only court-based is available. The other programs are not available except for the one state program, correct?
Yeah, I was about to say, technically, I mean, we're still accepting cases through court, so you can say it's open, but in regards to like there's just a regular round of funding, we closed that application back in December, like December 18th.
So Dan, what are some of the reasons, or Bob or Michael, or what are some of the reasons a landlord would not want to accept rental assistance? There seems to be some resistance here. What are some of the reasons you're hearing?
That's what I would like to know.
I could tell you what we're hearing sometimes is I think it's just, for whatever reason, the relationship is broken with the tenant to the point where they just want to get the tenant out. Michael, you may have some clients like this. And we don't, we can't force people to stay in their unit. We still think there's better solutions that can get negotiated than going all the way through eviction with the sheriff, but sometimes it's just not possible. But
yeah, I mean, that's generally, there are a couple of reasons. By and large, if rental assistance is on the table, most of my clients have accepted it and worked with the process. And sometimes the tenants, as Bob said, the relationship is so broken down, the tenant just wants to move anyway, but they also don't want to get a judgment on their records. So they work with their process. The money gets to the provider and the tenant moves out at some date. So essentially everybody, walks away without having a scar on the record. I mean, there are a couple of reasons that providers don't like to go through the process. One is sometimes there's more than just money going on in terms of the problem. And that was the case even before COVID. Some of the judges expressed surprise about that, but a number of the situations where it's just a 5-day notice for a non-payment of rent, there are other issues going on, whether that be disturbing other tenants, drug use, prostitution, things like that. So 5-day notices sometimes will get those cases in the court faster. But one of the main reasons that I've heard clients turn down rental assistance is they don't want to have to go through this again in 3 or 4 months, because rental assistance will cover all the rent now and as well as 3 months going forward. But in most cases, they're certain that on that first day of that 4th month, they're going to be having, asking where the money is again. And again, these are small and mid-sized providers. I can't imagine larger providers are that reluctant, but small and mid-sized providers very much are, because in most cases, then that 4th month comes and they don't have their rent. Again, they're dipping in their own money. Again, you've got another 5 to 6 month process ahead of you. And again, it's exasperating, not to mention the attorney's fees and court costs they have to pay. So, again, it's one of those situations I think you'd find a different answer among the larger providers versus the small and mid-sized.
Michael, if you work out a payment plan through the ERAP program, does the case stay open in case you have to enforce non-payment on a payment plan?
Yes, I mean, generally speaking, the other thing that is worth mentioning here, both the Chicago RLTO and the suburban RTLO have provisions in there now basically saying that if a tenant comes up with all the money, even if you're in the middle of an eviction case, if the tenant comes up with all of the rent due to that day, as well as the court costs, the provider has to accept it and the case gets dismissed, and they can do that one time. That's only really going to be possible during the rental assistance program, because it's unlikely otherwise that a tenant's going to be able to come up with such substantial amounts of money in a short period of time. But to Mike's question, basically, no, I mean, the payment plans keep cases alive, but their payment plans are generally not going to be involved with rental assistance. For example, the few that I have in terms of payment plans and rental assistance, for whatever reason, rental assistance came in dribs and drabs, 1 or 2 or 3 different payments. So all we do is we just continue the case down the road so that the other funds can come in. But by and large, if it's a payment plan, it's not going to be rental assistance. By and large, it's going to be, a tenant paying over some longer period of time. The case essentially gets dismissed, but with leave to reinstate it if the tenant falls behind, so that it gives everybody the motivation, gives the provider the motivation to keep the case going and let the tenant stay, gives the tenant the motivation, the incentive to make the payments.
It just seems like the ultimate irony that we have to file an eviction to tap into this assistance. Michael, what is the advice that when you talk to your clients who have somebody who is not paying, what is your advice given the lay of the land these days? Is it to file? And
it depends on it depends on the circumstances. If it's just a money issue, as you said, and in many cases it's a money issue over many months, they basically have to get into court. And if it is just a money issue, the vast majority of those get worked out because of the ERA. The ERA funding during the cases has done very well. I mean, it's efficient, it's thorough. It covers rent even going forward. So if it's just a money issue, what I tell people is, you're going to have to get it into court if you want to work out the money. If the tenant's usually, again, at that point, the tenant is multiple months behind and there's no way they can come up with that kind of money in a short period of time, then, getting the case in court is still an option. And to the extent the tenant balks at it because they don't want their name publicly out there or something, the current statute, at least until August of this year, also allows the provider and the tenant to come to an agreement to seal the file by agreement. And some providers do that, again, as an incentive to, have the tenant work with them about either paying or moving out. That I think it's August 20th, if I remember correctly, is the expiration date of that statute this year. So we've had a few of those where everybody's come to an agreement to basically seal the file, even though it's back public as of April 1st.
Okay, thank you for that. Obviously, there's so much more we could go into. Bob, will the early resolution program where services are brought, including emergency rental assistance, when emergency rental assistance is tapped out, whether that happens in December of this year or in the early months of next year, when there is no more emergency rental assistance, will this program, the ERP programs that seems to add another step, still exist?
Yes, I think the county and the court are committed to having the program for the long haul. And honestly, they are really trying hard to make sure the rental assistance component continues as well beyond early next year. I think Dan said, everybody's working on ways to try to keep it going as long as possible. But it may evolve if that's not going to be an option anymore, or it's not going to be a very limited option back to when, they're used to the city and the state had some emergency rental assistance funds available sometimes, in a more limited way. It may evolve and the process may evolve, but with or without it, we are committed to getting this process working more efficiently. The idea was really not even 4 to 5 months, as Michael pointed out in the beginning, was, to take the first couple months to try to figure out, are we going to be able to resolve this or not, short of eviction? And if we're not, let's get it to trial and get it moving, so that it's more like 3 to 4 months as opposed to 4 to 5. Right now we're at, 5+ sometimes for the reasons that Michael pointed out in his, thing. But we're committed to getting that working more efficiently again, so that at minimum we're working as quickly as we were before the pandemic. Hopefully even more quickly for you. Again, this is intended to be a balanced program for all concerned, and to help landlords who have either tenants who are, dangerous or other issues going on, or just can't resolve these cases, to be able to efficiently resolve them in the court. And I think everybody in the court, clerk, sheriff, and everybody else will say the same thing. That's what we're all committed to doing, is making sure we're leveling the playing field, giving everybody a fair shake, but keeping the cases moving as fast as possible.
Okay,
it's just there's some particularly challenging times right now to try to do that, but we're working through them.
So I'm going to have one more question. I'm going to ask folks if we can stick around for another few minutes, because I would like to hear from the clerk of the circuit court and from George from the sheriff. But there seems to be some frustration. Most housing providers are good business people, and we make rational decisions whether to participate in the early resolution program. Get emergency rental or not. What I see is frustration that if we opt not to participate, we want our unit back for whatever reason, and the tenant gets the money. What happens? The tenant can stay, or what's the scenario once the landlord says, I don't want to participate? It's his right, but the tenant gets the money. Is the tenant unduly enriched then, and can just take the money and do whatever they want?
I'll let Dan answer that second part about if there's not a resolution. Michael Zink pointed out the city ordinance says if the tenant can pay the full amount, there's a one-time option to pay that off, whether the landlord wants to take it or not, if the case is only about non-payment. If there are other things going on, like other reasons that you're trying to get possession, so that's the only scenario where the landlord would have to, I'm going to put in quotes, have to cooperate. As to money being paid to the tenant when the landlord is not cooperating, Dan, I would refer that to you as to what the circumstances are around that.
Now, when you say, okay, so in regards to court, so we do provide assistance for rent. So let me rewind. So basically, for Department of Housing, we don't have anything, we don't have a mechanism to provide like a security deposit in first month's rent. So if an applicant is approved and a landlord decides not to opt in the program, we typically don't give that whole amount that is owed. We'll provide 3 months of assistance, and that can, and we don't have a mechanism of making them pay or use that money towards, you know, whatever they use it towards. If that make any sense to you. I know it doesn't make any sense to you, but we don't have an enforcement mechanism at Department of Housing.
Yeah, it's a challenge. I can see the issue.
Right. What we can do is we do report to our OIG and we do report to the Department of Treasury information in regards to fraud. So we do have an ongoing list of names and documentation that we do report back to Treasury. What they're going to do with it, I don't know. We haven't got any guidance in regards to what they're going to actually do, but we do report those instances.
And if a landlord sees fraud,
absolutely.
Where do they go with that allegation of fraud?
Yep, they can report that actually to me at the Department of Housing, and we will forward that on to our OIG as well as the Department of Treasury. Okay,
thank you so much for that. I encourage folks to be in touch with their lawyers for more information. Somebody makes the proper observation that, you know, tenant selection in light of these circumstances is more crucial than ever before. The important cog in this wheel is the clerk of the circuit court's office, and we're pleased to have Carmen Navarro-Chacon on the call. And Carmen, thanks so much for your patience and being on this call and listening. Do you have any thing from the clerk's office that you'd like to share with us?
Well, good afternoon, everyone. Thank you for inviting us. I came to the clerk's office December 1st of 2020, and Iris Martinez, Madam Clerk, is very involved in wanting to know exactly how our office interacts and what role we can play, and if there's ever room to expand or learn, so that we're able to refer people to the resources that are out there to serve them, both the landlords and the tenants. So I thank you. No need to thank me for my patience. I learn every time I join these meetings, so thank you. I just wanted a few quick updates as far as our office, new hires. We did hire in the clerk's office 160 new employees since Clerk Martinez has come in. We're in the process of promoting 24 new court clerk trainers and 113 more court clerks. And we're going to be reposting for an additional 200 entry-level positions. So we are staffing up so that we can keep up with the demands of the court and the courts, the judges, to make sure that we're staffing the courtrooms and so that we can help the litigants with questions. We're still looking at opening the call center as well. So we're definitely looking at ways to continue to serve since there's enough aggravations with just the process itself. I do have Amy Rosinski, who's the Assistant Chief of the Civil Division, and Janet Hunter, who is the Chief Deputy Clerk of our Civil Division. And I just wanted them to address, I know at the beginning there were some issues with transfer orders and some of the delays, and just understanding the new system and where you can see cases. So Amy or Janet, if you wouldn't mind just taking a few seconds.
Sure. Good afternoon, everyone, and thank you all for having us. One of the challenges that we did have was a new case management system, an Odyssey case management system. Civil Division went live in December of 2021. We've trained our staff, our court clerks, and our judges, so we're still working through that process. And the issue with the transfer orders, I think, was part of when it migrated to the new system, but we've come up with a new program where we added another court call so we can track this better to make sure that the transfer orders that we're receiving are getting to our presiding judge and getting processed in the most expeditious manner. So we are definitely working, and we're listening, and we're always, we're open to suggestions on how we can improve and just make this process smooth, because it has been a challenge for all involved.
Well, thank you so much, Janet. You know, it's exciting to know that in various levels of county government, we're updating computer systems, and it's never easy. We all, as business people, know what it's like to graduate to a new generation of computer software. But for us, it's usually one generation. We know that with the county, whether it's the assessor's office or your office, you're dealing with computer programs that are decades old, I think. And so it's a very challenging to upgrade. You've been upgrading to this Odyssey program, and we're hoping that there will be a lot more efficiencies and better processing. And it sounds like if somebody has a son or daughter home from college, graduating, looking for an opportunity to work for the clerk's office, there's jobs available then, right?
Yes. As I said, we're promoting our court clerks now. We're going to have 115 immediately court clerks, which is going to open their spots along with the positions the county board was gracious enough to allow us to keep our open positions. So we're going to have another 200 entry-level positions posted by July. You have to be 18 or older and a high school graduate. So if they're home from college, there's plenty of opportunities. You all know attorneys and judges who started off as clerks in working with the clerk of the circuit court. So it definitely is a good career path. And we'd be excited to have them. So please look out. And I saw someone put in, the clerk's website was down for a while. It is up now. We'll put it in the chat box. It's up and it's working. We appreciate any feedback on it. They worked very hard. And that's why you had to wait so long. That's my story and I'm sticking to it.
All right. Well, look, with this new system in place, we're looking forward to these efficiencies, bringing about a more expeditious process to get these cases resolved. Finally, George Vernassos with the Cook County Sheriff's Police. George, you there still?
Sure I am.
Welcome and thanks for being here. Tell us what's going on with the Sheriff's Office and how it pertains to the eviction process.
Well, we're basically back to our normal procedures pre-pandemic. The only change is we are requiring a verification of non-rental assistance. As soon as those programs have run their course, we will probably discontinue that, obviously. And it normally takes us about 3 weeks currently once you file the eviction with us. A lot of people ask us, how can we make sure the process doesn't get elongated? I put some information in the chat, which contains our website to get to our social services page, along with a phone number. A lot of people are under the misconception that the social services that we try to render to the elderly or people who are disabled or that have many small children is going to slow down the eviction. It really doesn't slow down the eviction if you give us a heads up. So if you're filing a case and you know that you have a tenant that might need some type of social services, you can call our social service department. That number's in the chat, and that'll red flag it for us. And then we can start the process of trying to reach out to that potential tenant and try to connect them with social services to make sure that when we get there to do the eviction, there won't be any delays. So I also put in there, if you have any questions pertaining to civil process, if you filed an eviction and you want to know where it's at process-wise, you can email our civil process division. Once you get the eviction order, if you file it with our office, you can email any questions you may have. I put that email in there. So that's really the best way. We have multiple people that monitor those email addresses and they normally respond. Usually it's within maybe a couple hours, but it's certainly within 1 day. So we're kind of back to normal. And I'd like to thank NABOA, everybody that we've dealt with through the pandemic, whether they were practitioners, the court, groups like NABOA, have been really wonderful to deal with. We kind of joke that here at the Sheriff's Office, we're in the middle. So it doesn't really matter what we do. we always have one side or the other disappointed or yelling at us. So we're doing the best we can. And during the pandemic, I think just the amount of compassion everybody had, how much everybody worked together coming out of the pandemic, we would hopefully like to see that continue because I think it is going to make the system run a little bit better.
Well, listen, I appreciate you. I appreciate Rebecca Levin, who we've been working closely with. We had Sheriff Dart on a call not so long ago. And, you know, to me, so much of the progress we can make is through technology. And I know that you guys have been bringing new technology and we have to utilize this technology to help you all being more efficient. I mean, if we know somebody's moved out, we have to make sure we let you guys know so that you don't waste time sending people out to our properties when they could be, you know, be where they really need to be. And technology can help with that flow of communication. So.
Yeah, and again, if you know you don't need one, you can email that to ccso.evictions at ccsheriff.org. It's in the chat box. Most of you get the pre-printed plaintiff's letter that actually, I believe that letter contains a box if you want to cancel it where you can fill that out and you can email it back to us. Yeah. So it's a simple process. So again, Mike, I'd like to thank you personally too for everything that you've done throughout the pandemic. And, you know, we go way back with Nebola. We were talking to you guys, you know, 6, 8, 9 years ago. Yeah. So we always appreciate the feedback.
All right. Well, when we're through this whole crisis, we're all going to have one big cocktail together and celebrate it. There's more questions. We'll have to take it up separately. Phyllis, I see your question. Thank you all for the program. A couple side notes. This meeting wouldn't have happened if not for the phenomenal efforts of our paid consultant, Mick Snyder, who I hope is still on this call. It was in January when we were hearing about 90-day return dates and problems that I asked Mick if he could take this issue on, and he, through some connections he made, was able to get connected to Bob Glaves, brought Mike Zink in, and I think I thank Mick and also Alderman Joe Moore for the efforts he's contributed. Our organization has these paid professionals that help make a huge difference. And I'm sure you guys have seen my appeals. If you feel like you've benefited from the work of the NBOA, the little bit of financial assistance or a lot of financial assistance, either way, it's an investment. You know, we have plenty of challenges out there, new challenges. It's a different landscape than 6 months ago. It's going to be a challenging landscape 6 months from now. We sure would appreciate the generosity and investment that all you on this call who are housing providers can offer us. Our website's nboachicago.com if you want to find the donation link. And through all this talk of eviction and the sad, there's also a bright light coming August 11th. You'll soon hear about another event that we in the NBOA have. It's our summer soiree. That means sunshine. It means food and drink and merriment. And we hope you all can come. The location's still being worked out, but put the date on the calendar. It's August 12th. And we'll soon be sending out requests for sponsors for any of you who want to assist us through a sponsorship. All that said, we ran 15 minutes over, but a lot of great material covered. Thank you, the civil servants on this call, for all of your hard work and your dedication and for participating today. And with that